The Bavarian city of Nuremberg was destined to enter history as the place where, in 1945 to 1946, the leadership of Nazi Germany stood trial before the world. It was the first time in history that state officials were prosecuted for crimes against humanity and what would soon be defined as genocide. On November 20, 1945, in Courtroom 600 of the Nuremberg Palace of Justice, something began that was more than a trial. The air, still carrying the smell of fresh paint and old fear, seemed crowded with ghosts, not only those seated in the dock, but the millions who were absent. Made possible by the fragile alliance of four victorious powers, the proceedings immediately confronted a problem never faced before: how to find legal language for crimes that had existed beyond the reach of law itself. In 2025, the film Nuremberg revisited these events, with Russell Crowe portraying Hermann Göring. But today we will look beyond the familiar story at the strange, overlooked details of the Nuremberg trial that rarely reach the public, yet are impossible to ignore. Why was the tribunal held in Nuremberg and not in Berlin or Munich? Part of the answer was symbolism. For the Nazis, Nuremberg held a special, almost sacred meaning. It was here, beginning in the 1920s, that some of the earliest mass propaganda rallies were staged, gatherings that would later evolve into the vast party congresses of the Third Reich. Nuremberg became the ceremonial city of Nazism, a stage where the regime performed its mythology of unity, power, and racial destiny. To place the trial there meant something unmistakable. The ideology was being judged in the very city that had once celebrated it. But symbolism alone did not decide the location. There were also practical realities. Although Nuremberg had been heavily bombed, the Palace of Justice survived largely intact. Crucially, the complex included a large prison capable of holding over 1,000 inmates, an essential requirement for a trial involving dozens of high-ranking defendants, witnesses, and guards. The Allied powers had initially disagreed about how Nazi leaders should be punished. Franklin Roosevelt and Winston Churchill had at times favored a more political approach: summary identification, brief interrogation, and execution of major Nazi figures. By contrast, Joseph Stalin and the French government insisted on a formal legal process in which each defendant would be judged for specific crimes. Once the decision for a judicial tribunal was made, another question arose: where could such a court actually function? The victors agreed that the trial should take place on German soil for ideological reasons. Yet most major German cities lay in ruins after years of bombing and battle. The proceedings required an enormous courtroom. The trial was public, and beyond judges, prosecutors, defendants, and witnesses, hundreds of journalists and technical staff had to be accommodated and housed. A joint Allied commission reviewed the available sites and chose the Nuremberg Palace of Justice, specifically Courtroom 600. During the trial, the building fell under U.S. jurisdiction within the American occupation zone. It was returned to German control only in 1961. Security inside the courtroom was handled primarily by U.S. Army personnel, with ceremonial guards from all four Allied powers. There was also a constant concern: escape or rescue attempts. For that reason, a secure prison near the courtroom was mandatory. Nuremberg again met the requirement. The prison stood just across the street from the Palace of Justice. For the duration of the trial, a covered wooden passageway was built between the buildings, allowing the defendants to be brought directly from their cells into the courtroom. In the end, Nuremberg satisfied every need at once: symbolic, ideological, logistical, and security. The city that had staged the great spectacles of the Reich became the place where the Reich itself was put on trial. One of the most iconic images from the Nuremberg trials shows the defendants, Göring, Hess, Ribbentrop, Keitel, and others, laughing in court. But what were they laughing at? And why did the men responsible for the greatest crimes against humanity suddenly break into laughter just before the verdicts? The photo was taken during the hearing of Alfred Rosenberg's defense, the chief ideologue of the Third Reich. The proceedings were conducted in multiple languages: English, German, Russian, and French. Defendants were given headphones to hear simultaneous translation. Rosenberg's lawyer, Alfred Toomer, relied on an assistant to hand him documents and operate the microphone. But at the exact moment the photographer snapped the picture, the assistant made a mistake, or Thomas himself mishandled the documents. The assistant accidentally handed him Rosenberg's infamous book, The Myth of the 20th Century. Dr. Thoma intended to pass it to the judges but suddenly realized the error and forgot to mute his microphone. Through the headphones, everyone heard Thoma explode. "Idiot! Why are you shoving this crap at me?" The entire courtroom, defendants, staff, and even journalists erupted into laughter. The only exception was Rosenberg himself, the man who had written one of the key ideological texts of the Third Reich, a book sometimes called the Second Nazi Book, after Hitler's Mein Kampf. Remarkably, the laughter was not limited to the defendants. Even Lord Geoffrey Lawrence, the British presiding judge, briefly chuckled at the absurdity. It was a fleeting moment where human reaction, surprise, embarrassment, and absurdity overrode the tension of the trial. For historians and psychologists alike, the photograph is a frozen glimpse of human complexity. Even monsters can respond instinctively to the ridiculous, and even in the darkest moments, a laugh can escape though for many of these Nazi leaders. These would be the last emotions they ever experienced. If you watch the newsreels from the Nuremberg trial, you'll notice an odd detail. Many of the defendants, including Hermann Göring, are sitting in the dock wearing dark glasses. They were not hiding their eyes in shame, and they were not concealing emotion. The reason was largely practical. For the first time in history, a major international trial was being extensively filmed and photographed. Courtroom 600 was equipped with powerful television and newsreel lighting, harsh, continuous illumination designed for early motion picture cameras. Contemporary observers repeatedly noted how bright the courtroom was under these lamps. Nuremberg also hosted an unprecedented press presence. Journalists from about 20 countries attended, with roughly 240 seats reserved for the press gallery alone. Cameras and flash photography were constant. Under this glare, many defendants complained of eye strain and requested tinted lenses. In that sense, the dark glasses were simply a response to the technological reality of the trial stage for the modern media age. A courtroom built not only for judges and lawyers, but for the watching world. The story of the dark glasses also has a more personal dimension, and it begins with Hermann Göring. Early in the proceedings, Göring complained that the camera flashes and intense courtroom lighting hurt his eyes. He requested permission to wear tinted glasses, which was granted. Soon, other defendants followed his example, but witnesses noticed something else. Göring would sometimes sit back in the dock, eyes hidden behind dark lenses, appearing detached, even drowsy. American guards and observers later recalled that he occasionally seemed to doze during sessions, the glasses masking whether he was watching, listening, or simply ignoring the proceedings. In that sense, the glasses served not only as protection from light, but as a small assertion of control, a barrier between the defendant and the tribunal, a gesture that suggested, "This court does not command my full attention." What began as a complaint about brightness became, in Göring's case, a quiet performance of indifference, a visual signal of how he chose to position himself toward the trial itself. Reports that Nazi defendants applauded at Nuremberg could be misleading if understood literally. There was no open, sustained clapping in the courtroom, but observers, including guards, journalists, and psychologists, noted repeated gestures of approval inside the dock, nodding, tapping, murmured praise. Even brief hand claps when a co-defendant made a defiant or ideologically charged statement. These reactions had clear meanings within the defendant's own world. When testimony framed Nazi actions as patriotic duty or state necessity, other defendants signaled approval. American prison psychologist Gustav Gilbert wrote that Göring encouraged a collective front among the accused and sought to maintain Nazi morale inside the prison and courtroom. Approval during testimony was one visible form of that morale. Multiple observers described how Hermann Göring treated the dock almost as a political caucus. Gilbert recorded that Göring saw himself as the natural leader of the group, openly scorning defendants he considered weak. Guards also noted that others looked to him before reacting. Gestures of approval often followed his cues, reinforcing his authority and the sense of hierarchy among the accused. Several defendants attempted to present their actions as legitimate state policy rather than crime. Supportive reactions turned individual testimony into a collective narrative. As one American observer summarized in post-trial notes, the dock sometimes behaved less like separate defendants and more like a cabinet in exile. Approval signaled, "This is our shared position." By late 1945, many defendants already anticipated severe sentences. Their demeanor therefore acquired what contemporaries called a bravado of the condemned. Gilbert observed that Goering in particular wanted to go down in history as a steadfast leader rather than repentant criminal. Approval of hardline statements was part of that posture, a way to preserve face before one another and before history. So the applause of Nuremberg was not joy. It was coded communication inside a defeated elite, signals of loyalty, hierarchy, and defiance exchanged on the edge of judgment. Inside the Nuremberg prison in 1945 to 1946, the Nazi leadership recreated a familiar order. Even in captivity, hierarchy survived. At its apex stood Hermann Göring, without serious challenge. Guards, psychologists, and fellow defendants all described the same pattern. Göring demanded deference, set the tone of conversation, and positioned himself as the moral center of the group. American prison psychologist Gustav Gilbert wrote that Göring saw himself as the natural leader of the defendants and worked deliberately to maintain what he called their Kampfgeist fighting spirit. He urged others to face the trial and possible death sentences with dignity, meaning without confession or visible remorse. Several defendants gravitated toward this pole of ideological loyalty. Field Marshal Wilhelm Keitel remained deferential to Göring and embraced the language of soldierly honor. Ernst Kaltenbrunner likewise projected defiance and ideological steadfastness. Among guards, these men were often described as the hard core around Göring, but the hierarchy also produced fractures. Those who attempted to distance themselves from Nazi crimes, shifting blame onto Hitler, the SS, or the dead leadership, rapidly lost standing in Göring's eyes. He openly scorned what he considered weakness or betrayal. Gilbert recorded that Göring spoke contemptuously of defendants who sought mitigation, insisting that leaders should accept responsibility collectively rather than plead innocence individually. Foreign Minister Joachim von Ribbentrop, anxious and increasingly isolated, never achieved equal status within the prison group. Rudolf Hess remained psychologically distant, partly outside the social hierarchy altogether. Guards noted that conversations and seating patterns in exercise periods often reflected this ranking. Göring central, loyalists near him, others peripheral. As one American guard later summarized in recollections, the prison sometimes felt less like cells and more like a staff conference of a defeated regime. The structure existed for a reason. Facing likely execution, the defendants were losing power, status, and future. Hierarchy became the last available form of authority. By preserving rank, loyalty, and ideological posture, they preserved, in miniature, the Reich itself. Even behind bars, they tried to remain what they had been. The first and principal Nuremberg trial, in which the major Nazi war criminals were prosecuted, concluded on October 1, 1946. Half of the defendants, 12 of the 24 indicted, were sentenced to death by hanging. The sentences were carried out during the night of October 16, 1946, with the exception of Hermann Göring, who committed suicide beforehand, and Martin Bormann, who had been sentenced in absentia, as his fate was then unknown. 3 defendants received life imprisonment, and 4 others were sentenced to prison terms of 10 to 20 years. 3 men were acquitted. From 1946 to 1949, 12 additional trials were held against other Nazi perpetrators, including physicians, jurists, industrialists, and members of the SS. Several defendants in these subsequent proceedings were also sentenced to death. Only now, with the distance of decades, can we fully grasp the significance this trial held for all humanity, not merely as an act of justice or a necessary legal procedure, but as an attempt to protect the future from crimes of such scale committed in the name of the state.